Good morning with PLL News. Today we have an unusual legal case related to a copyright issue, which is a case of a selfie monkey, Ms. Pet.
Thank you, Ms. Lily. So the copyright we're going to talk about today here isn't just copyright for a human, but for a monkey. The story was there was one British photographer, Mr. David Slater, who traveled to a national park in North Sulawesi, Indonesia, to take pictures of local wildlife in 2011. He followed a troop of monkeys and stayed with them for a few days, trying to get the few unique pictures of a very close shot of monkey's face, but didn't achieve in the very first trials.
He then placed his camera on a tripod as the monkey was curious about the equipment, and then he clicked on the shutter. Unfortunately, the picture was in poor quality. He then claimed that he changed the camera settings and that one monkey in particular was drawn attention by the lens of the reflection. The monkey then went to take a few more pictures as the result in the picture of a selfie monkey. We later then know that the name of the monkey was Naruto.
Mr. Slater likes the picture very much as it captured the expression of pure joy and self-awareness of Naruto. He imagined it appearing on the cover of National Geographic, so he sent the picture to his agent, who then circulated them to a number of news sources. Eventually, it was picked up and published by Daily Mail as a feature story and then went viral.
Then in 2014, there was a dispute with Mr. Slater and Wikipedia of a copyright infringement, as Wikipedia used the picture on its website. Wikipedia claimed it's on the public domain, so no one had a copyright of the picture.
Then, in 2015, that's when the campaign group People for the Ethical Treatment of Animals, or PETA, came in and sued Mr. Slater on behalf of the monkey, or Naruto, for the copyright over the picture taken, claiming that the selfie is made by Naruto clicking the button, so copyright of the picture should belong to Naruto.
PETA filed a lawsuit on Naruto on behalf of Next Friend, which is a legal status very similar to a guardian of minors. PETA claimed that Mr. Slater had infringed the monkey copyright by releasing Wildlife Personalities, a self-published book of photography that included the famous monkey selfie.
All judges agreed that animals in general cannot be represented by Next Friends. Plus, in order to earn a copyright for a piece of work, there must be a series of acts that can convey originality in a photograph, not just physical act of pressing the button. There must be three main elements, which are first, the angle of shot, light and shade exposure, effects, and developing techniques in which Mrs. Slater has done by adjusting the camera setting. Second, the creation of the scene of the photograph, which is in Indonesia, where Mrs. Slater intentionally traveled there to get the picture of the monkeys. And then third, being in the right place at the right time, in which Mrs. Slater was there when monkey presses the snap button on the camera.
Later, PETA has dismissed the appeal when it reached a settlement with Slater, requiring him to donate 25% of the earning of his book to charity that protected the habitat of Naruto and other crested macaques in Indonesia. But this really bothered the appeal court judge, as they said was how PETA sought to abandon the case after reaching a settlement that did not direct benefit Naruto and instead serve PETA's institutional interests.
Today, the court reaffirmed that no animals have the constitutional right to bring a case to a federal court when they've been wronged.
So that's a wrap for today. Thank you for watching PLL News. See you tomorrow morning. Have a good day, and first,
Let me take a selfie.